Hi friend, welcome to the Company Law Adjudication and Appeal Series. Today we are discussing Bangalore ROC adjudication order in the matter of the Chaitanya India Fin Credit Private Limited for the violation of section 161 of the Companies Act. Dear friend, company name is the Chaitanya India Fin Credit Private Limited, was incorporated in 2009 under the jurisdiction of the ROC Bangalore. The register office of the company is presently situated at Bangalore, Karnataka, and as per section 161 subsection 1 of the Companies Act, which stipulates that the articles of a company may confer on its board of directors the power to appoint any person other than a person who fails to get appointed as a director in the general meeting as an additional director at any time, who shall hold office up to the date of the next AGM or the last date on which the AGM should have been held, whichever is earlier. Whereas the company has filed its adjudication application on 23rd December 2021 under the caption Nature of the Contravention, the following issues are mentioned. First issue, the company had appointed Mr. Sachin Bansal as the managing director and CEO of the company by resolution dated 27th February 2020 for a period of the 5 years from March 6, 2020. However, by inadvertence, the board had omitted to co-opt him as additional director before appointing him as a managing director. As a consequence of the board having so omitted to appoint him as additional director, the approval for his appointment by the shareholder regularization at the first AGM of the company held on the 18th August 2020 after appointment was omitted to be obtained. As a result, said director is deemed to have vacated him office with effect from 18th August 2020 in terms of the section 161 of the Companies Act. However, the company did not notice this omission till 18th October 2021. Immediately, the company at the board meeting held on 19th October 2021 took on record the cessation of the office of the director with effect from 18th August 2020. Dear friend, considering above the facts about the board resolution, it is noticed that the company has violated the provision of section 161 with effect from 6th March 2020 to 18th October 2021. The delay in compliance of the provision is 591 days. As per the provision of section 172 of the Companies Act, if a company is in default in complying with any of the provision of this chapter and for which no specific penalty or punishment is provided therein, the company and every officer of the company who is in default shall be liable to a penalty of the 50,000 rupees, and in case of the continuing failure, with a further penalty of the 500 rupees for each day during which such failure continues, subject to a maximum of 3 lakh rupees in case of a company and 1 lakh rupees in case of an officer who is in default. And whereas the matter was heard on the 24th May 2022, and accordingly the ROC, in exercise of the power vested under section 454 subsection 3 of the Companies Act, imposed penalty as under on the company, that is the maximum penalty that is restricted to 3 lakh, and managing director maximum penalty restricted to 1 lakh. However, calculation, as per the calculation, there is a penalty is the 3,45,500, but maximum penalty 1 lakh, and CEO on 1 lakh, and one CFO 1 lakh, and company secretary, there is 2 company secretary, and both company secretary have officer in default, and impose penalty on the company secretary 1 lakh each, and on the 2 CFO also, then 2 CFO, that is the maximum penalty imposed 1 lakh each, and 1 additional director 1 lakh each. So total penalty is the 10 lakh for this default. And ROC direct that they shall pay the penalty amount from their own sources through MCA portal within 60 days from the date of the receipt of the order. The company need to file INC 28 as per the provision of the Act, attaching copy of the adjudication order along with the payment challan. And as per subsection 5 of section 454, provide that any person aggrieved by any order made by the adjudicating officer under subsection 3 may prefer an appeal to the regional director having jurisdiction in the matter. Every appeal under this section shall be filed within 60 days from the date on which the copy of the order made by the adjudicating officer received by the aggrieved person, and shall in such form and manner and accompanied by such fee as may be prescribed, and where violation on failure to comply with this adjudication order under subsection 3 or subsection 7, in that case, within a period of the 90 days from the date of the receipt of the copy of the order, company shall be punishable with fine which shall not be less than 25,000 rupees but may stand to 5 lakh rupees, and officer in default that is not less than 25,000 rupees which may stand to 1 lakh or both. This is the penalty. In case of the default in payment of the penalty, then prosecution will be filed under section 454 subsection 8 1 and 2 without any further notice. This is the order dated 5th July 2022 for the violation of section 161, that is total penalty imposed in this case 10 lakh. Thank you so much for watching this update.